Okay, let me present. I'm just going to share my screen. This one. Okay, did we stop here? Last meeting, Article 1217, payment made by one of the solidary debtors, extinguished. Extinguishes the obligation. So even if it's just one debtor who paid the entire obligation, it extinguishes the obligation of all the debtors, subject of course for the one who paid the entire obligation, the right to collect or recover from the other debtors. So he who made the payment may claim his co-debtors only the share which corresponds to each, with the interest for the payment already made. If the payment is made before the debt is due, no interest is for the intervening period may be demanded. So if it was paid ahead of the due date, you cannot compel your co-debtors to pay interest from the time when you paid it. It was your voluntary act to pay ahead, so you cannot compel interest. Interest will only be imposed upon payment when the obligation is already due and demandable. When one of the solidary debtors cannot, because of his insolvency, reimburse his share to the debtor paying the obligation, such share shall be borne by all his co-debtors in proportion to the debt of each. Okay, so for example, if A, B, and C are co-debtors of 750 pesos, and then A cannot pay his share, B and C will share um, in the 250 share of A, um, being solidary debtors. Okay, so because A has become insolvent. Okay, so what are the effects of payment by a solidary debtor? So between the solidary debtors and creditors, payment made by one of the solidary debtors extinguishes the obligation. And speaking of payment, that extinguishes an obligation. Okay, the law refers to payment in full. However, creditor for his protection is given the right to choose which offer to accept if two or more solidary debtors offer to pay. So kung ito, di ba, if and when it happens, then the creditor has the right to accept, okay, has the right to choose which ones to accept, okay. And then among the solidary debtors, payment by one of the solidary debtors does not create a real case of subrogation. It merely entitles him to claim reimbursement from his co-debtors, meaning only the share which corresponds to each, for their proportionate shares with legal interest only from the time of payment. Sir, what does it mean when you say does not entitle him a real case of subrogation? Because the debtor here does not become a creditor of a solidary debtors. He or she will only be able to compel each co-debtor their share of the debts. Unlike when it's a creditor of a solidary obligation, the creditor can actually compel at just one debtor to pay the entire amount. Okay, so that's the difference between subrogation and just the claim for reimbursement. So the case of payment of a solidary debtor of an obligation is just the case of a claim for reimbursement. That whatever he paid as in behalf of the co-debtor, he will be able to recover as a way of reimbursement. Among the solidary creditors, the receiving creditor is jointly liable to the others for their corresponding shares. Okay, so let's go to Article 1218. There's just a few articles in this topic though, but let's go to Article 1218. So payment by a solidary debtor shall not entitle him to reimbursement from his co-debtors if such payment is made after the obligation has prescribed or become illegal. So in such cases where there is an obligation by a solidary debtor, and one of the debtors of a solidary obligation paid the obligation even after it has prescribed or has become illegal, that solidary debtor who paid is no longer entitled to reimbursement. In the first place, it's no longer due and demandable if it has already prescribed. So, what does prescription mean here, sir? Prescription means this is not about prescription of medicine, when you're talking about medical term. It's not the prescription of medicine. Prescription here is when obligation has prescribed, it means it ceases to be due and demandable. It's no longer due and demandable. Okay, meaning it has expired. Okay, it has lapsed enough time for the obligation to be paid. So there are certain provisions of prescription of an obligation. So once the obligation has prescribed, then you are no longer required to pay. However, if you did pay, then you can no longer recover from your co-debtors. Because in the first place, the defense of the co-debtors would be that it's no longer due and demandable. Why would you pay that? Okay, so the effect of payment where obligations already prescribed or become illegal. Here in 1218, it mentions two cases when the paying debtor cannot get any reimbursement. Okay, when the obligation is prescribed or become illegal as the obligation is extinguished. Okay? Hence, there is no more obligation to be complied with. Wala nang obligation because it has prescribed. It has already been extinguished. And the mode of extinguishment, if you're asked, the mode of extinguishment is by prescription. Because there are different ways to extinguish an obligation. And one of them is by prescription. Of course, there's other methods of extinguishment of debt. What are those? Those we previously mentioned and covered, like confusion, merger, okay, novation, all the other provisions that we have gone through earlier. Right now, this is about prescription. Another mode of extinguishing a debt or obligation is by payment, diba? The easiest way and the most common way, by payment of the obligation. Here, the payment of the obligation is no longer necessary because it has already been extinguished by prescription, but because one of the debtors paid, then he or she can no longer recover from his co-debtor such share of the payments in a prescribed obligation. Okay? So, prescriptive periods, for your information, by prescription, one acquires ownership and other rights, though through the lapse of time in the manner and under the conditions laid down by law. The following actions must be brought within 10 years from the time the right of action accrues: upon a written contract, upon an obligation created by law, and upon a judgment. The following actions must be commenced within 6 years. These are the things. Upon an oral contract, 60 years yan, or upon a quasi-contract within 6 years. You should have filed an action for these types of obligations to not prescribe. Okay? 10 years kapag written contract, obligation created by law, and upon judgment. And the following actions must be instituted within 4 years upon an injury to the rights of the plaintiff and upon a quasi-delict. So most crimes, the prescription would be, most quasi-delict. Quasi-delict, what is meant by quasi-delict? Again, we have quasi-delict or quasi-delict. What do you mean by that? Again, we have covered this last meeting. What do you mean by quasi-delict as opposed to delict? You can remember? Anyone?
When they arise from damage and cause another through an act or omission.
Through an act or omission? Was there intention in a quasi-delict?
Act of negligence, sir.
I'm sorry, Neil?
Act of negligence.
I can't hear you clearly. Can you say it again?
Yes, sir.
Go ahead.
the act of negligence, sir, where there is no
Negligence.
criminal intent, but there is damages or injury to the
Correct.
affected person.
Correct. So when you say quasi-delict,
Yes,
there
sir.
is no intention to harm, but there was injury, and therefore there is damages. There is cause for damages, and therefore to claim damages. And for those types of incidents and obligations arising from quasi-delict, you're only given up to 4 years to file an action. Failure to file an action within 4 years, even though you suffered an injury, you can no longer recover, okay, or you can no longer demand the obligation, the because it has already prescribed. So these are some guides of prescriptions. There are still other prescriptions in different, but these are in different provisions of the law. But these are the general provisions. Okay, if it is a written contract, the action accrues upon a written contract, then it's 10 years. That's why it's always advisable to put the contract in writing because it has a longer term of prescription, 10 years. Okay, you're given 10 years. Okay, the right of action accrues upon a written contract, it's 10 years. And also upon an obligation created by law, if it's the law that created that obligation, meaning it is expressly stated in the law or it is prescribed in a law, then it is 10 years. Or upon a judgment, if there is judgment, of course, you have to exert an effort to also recover as what the judgment has indicated, and you have to have that action filed within 10 years. The following actions must be commenced within 6 years upon an oral contract and quasi-contract. So, if it's just oral contract, the number of years of prescription is lesser. It's now just 6 years. And upon a quasi-contract, these are the solution indemnity and what's the other one? What's the other quasi-contract? Still remember last meeting we discussed?
Go showroom gesture, sir.
Okay, good. Negosyorum has Joe. Okay,
Sir,
thank you, Chan and Ivy. So these are the prescriptions. You can take note of these so you'll remember. Okay, and then you can apply in specific cases. What are the effects of remission of share after payment? So if a payment is made first, the remission or waiver is of no effect. There is no more obligation to remit in the first place because it has already been paid. If remission is made previous to the payment and payment is made, solutio indebite arises. It is incumbent upon the debtor whose debt is remitted to prove the priority of the remission to the payment to release him from responsibility towards his co-debtors. So, kung kunyari, parang na-remit, meaning it's when there is remission of obligation, therefore the obligation has become extinguished due to remission. Okay? So, na-condone. Okay? It has been forgiven. Okay? So there's no obligation at all to pay. But if it was paid, then this gives rise to solutio indebite. We know what solutio indebite, right? It's the transaction or it happens when a payment is made when there is no legal
When there is no right to demand, sir.
when there's no legal right to demand this the fulfillment of the obligation. Okay, so it is paid by mistake. So in this case, it is paid by mistake by one of the co-debtors, maybe not knowing about the remission. If it was paid after the remission, okay, then the obligation has become a case of solutio indebite, and therefore, of course, whoever claims that it was previously remitted, that remission actually happened before the payment, should prove that there was actual remission. The purpose of this article is to forestall fraud whereby the debt having been paid, the creditor who does not stand to suffer any loss or damage remits the share of a particular debtor. The article also secures equality and justice to the paying debtor inasmuch as the payment benefits his co-debtors. Okay? Okay. Okay, let's go to Article 1220. The remission of the whole obligation obtained by one of the solidary debtors does not entitle him to reimbursement from his co-debtors. So no right to reimbursement in case of remission. The reason for this article is that the debtor who obtains remission pays nothing to the creditor. Therefore, remission is essentially gratuitous. It is really a donation. Observe that article applies only when the whole obligation is remitted. In case of novation, compensation, or confusion, the debtor with whom it is effected is entitled to recover from his co-debtors their corresponding shares of the obligation. Um, what does this mean, sir? Again, this one, the remission is for the entire obligation. In the previous provision, this one, just a portion of the obligation is remitted and then it was paid as a whole because there are co-debtors. No? Here, there are also co-debtors, but this article refers to when the obligation is entirely forgiven. Okay, so regardless of who is the cause of the remission, the one who caused the remission of the obligation is not entitled to reimbursement. Again, because according to the law, there was no actual payment. Okay? And the nature of the remission is essentially gratuitous. So kung wala ka namang binayaran, na-forgive or na-condone lang yung obligation, you are not entitled to recover. Okay. The next article, if the thing has been lost or if the prestation has become impossible without the fault of the solidary debtors, the obligation shall be extinguished. Okay. So if there was fault on the part of any of them, all shall be responsible to the creditor for the price and the payment of damages and interest without prejudice to their action against the guilty or negligent debtor. If it's through a fortuitous event, the thing is lost or the performance has become impossible after one of the solidary debtors has incurred in delay through the judicial or extrajudicial demand upon him by the creditor, the provisions of the preceding paragraph shall apply. Okay? So, if there was fault on the part of any of them, all shall be responsible to the creditor. So, in the eyes of the creditor, they are responsible. Okay? Subject, of course, to damages and interest. Of course, the debtor who is not at fault can also recover from the guilty or negligent debtor. Rules in the case in case the thing has been lost or prestation has become impossible. If there is no, if loss is without fault and there's no delay, and loss is due to fault on the part of solidary debtor and loss is without fault but after delay. Okay, so these are the defenses available to solidary debtors. Defenses derived from nature of the obligation, defenses personal to or which pertains to share of debtor stood, and defenses personal to other solidary debtors. So a solidary debtor may, in actions filed by the creditor, avail himself of all defenses which are derived from the nature of the obligation, okay, which are personal to him or pertain to his own share. With respect to those which personally belong to the others, he may avail himself thereof as regards that part of the debt for which the latter are responsible. So up to his share lang. Okay? Okay, so if you go back to this provision, it says that if the thing has been lost or if the prestation has become impossible without the fault of the solidary debtors, the obligation shall be extinguished. So these are the rules. That the loss is without the fault and before delay, and loss is due to the, or if the loss is due to fault on the part of the solidary debtor, then all shall be responsible. This is the provision, all. If it's fortuitous event and there is no delay, then the obligation shall be extinguished. Okay? If lost without fault but after delay, this paragraph here applies. Okay? Even if it's through fortuitous event, because by default, as we've discussed in the previous meeting, by default, if the thing is lost or if the performance of the prestation has become impossible, if there was no delay and it was due to a fortuitous event, meaning there's no fault at all in the part of the solidary debtors or to the co-debtors, then the obligation is extinguished. That's Article 1221. And it goes without saying that if there is delay, okay, if there is fault on the part of the solidary debtor, or if there is without fault but after delay, this 2 and 3 here, this is the applicable provision. The delays for judicial or extrajudicial demand upon him by the creditor, the provisions of the preceding paragraph shall apply, meaning this this obligation is not extinguished here because it is already after delay or if with fault. Okay, so these are the rules. It should be lost without fault and before the delay. Meaning of delay, meaning the obligation is not yet due and demandable and the thing or the prestation has become is lost or has become impossible. Okay, it will be extinguished. If it's due to fault or if it's due to fortuitous event but after delay, meaning after the obligation has become due and demandable, you can no longer set up the defense of fortuitous event. Therefore, the obligation is not extinguished. Okay, it is still going to be recovered by the creditor in terms of maybe the price or the value of the thing lost or the value of the prestation plus of course the damages and interest. Okay, so what are the defenses to a solidary debtor? These are the defenses. Defenses derived from the nature of the obligation. Defenses personal to or which pertain to share of debtor sued, and defenses personal to other solidary debtors. If the obligation to other solidary debtors is personal to other solidary debtors, you as the one of the co-debtors can set up defense and say, hey, this is personal to these other solidary debtors. I cannot be compelled to do this or to deliver this. If it's derived from the nature of the obligation, that this is the nature of the obligation is this, so this is only my share. If the defense is personal to or which pertain to share of debtor sued, if it's only limited to his or her share. Okay. Okay. So I think that's it for this part of obligations and contracts, pure and conditional obligations. Okay. Let me share you this verse. Once you have voluntarily made a vow, be careful to fulfill your promise to the Lord. And that's it for this topic. Any questions? Thank you. I'll proceed to the next topic if you have no questions.